from bail list for hearing under the 41 Rule 11, Item 23, Second Appeal 85 of 2022.
The second appeal is directed against an order dated, a judgment dated 7 June 2020, by which the appellate court has reversed the order passed by the learned trial courts.
You are the plaintiff or the defendant?
I am the defendant. The basic premise of this case.
The suit was dismissed?
The suit was dismissed. The suit was.
Yes. One. What are the suggested substantial question of law? Let me just have a look at it and then I will listen to it.
Yes, please.
Which one are you referring
G.
to?
G nahi, sir. D and G. D and G.
D and?
G. D.
What do you mean exclusive ownership of?
What has happened, my girls, in this case, the defendant happens to be the nephew of the plaintiff.
Sole defendant?
So, defendant now, heirs have been substituted and heirs are representing
Original sole.
original suit.
Nephew of the plaintiff? Okay.
Now, the plaintiff has made and tried to create a cause of action that I was a licensee, being a nephew, I was a licensee under the plaintiff. And since I inducted somebody else for a certain period of time, therefore an eviction notice, normal eviction, not a BDC Act case, normal eviction notice under the garb of license was issued. The learned trial court
So eviction notice for violation of terms and conditions of license?
No license has been exhibited.
No. It could be oral license.
Well, it can be, but then if bylaws point is that, I was going through it yesterday, then he has to fall within the purview of section 53 of the Indian Easement Act. Because the Sikmidar, because the trial court held that the Sikmidar right, the land belongs.
Who's right?
The ownership of the land which is there, the learned
Ancestor of the
ancestor,
parties.
yes,
Ancestor of the parties.
ancestor, the original land belongs to a Sikmidar thing, so which is not transferable or inheritable. So,
Then how did the plaintiff or the defendant get possession?
plaintiff says by virtue of sale deed. Plaintiff says by virtue of sale deed. Learned trial court comes into the conclusion that since the Sikmidar land is not transferable, my contention is secondary, that thing. We're not transferable, therefore. But if I come in the purview of section 53, which my lord is asking that it can be implied also, section 54 of Easement. But if it is not transferable and a license can be transferred of the interest which I can transfer out, capable of being transferred. If the land is Sikmidar, this is a proposed substantial question of law, then I cannot fall within the purview of licensee. Secondly, my lord, there is a category.
No, it's not, the facts are not very clear. Who is the Sikmidar? Who is the Sikmidar?
I'm just coming.
You just give me this
name of that person.
Yes, name of Sikmidar.
Yes, Manas.
And is it admitted fact that he was Sikmidar?
It's dealt in issue number 8 of the learned trial court. Rakhal sir.
Rakhal. Okay.
And the learned trial.
How does the property come to the plaintiff?
Plaintiff has stated that he has purchased the land by virtue of sale deed.
Sale deed. Okay.
Defendant rebuts the contention that plaintiff was a student at that point of time. My father was a government employee, so he purchased in the name of the plaintiff. And since I belong to the nephew, by birth I was residing there. I was not a licensee. This finding has been reversed by the appellate court that since I cannot demonstrate any co-ownership because the sale deed is in the name of the plaintiff, therefore I am a licensee without examining the fact that whether he had the transferable right within the purview of section 53 or not. These are my proposed substantial question of law. For that reason, D substantial question of law was taken.
The sale deed was executed by Sikmidar in favor of
Plaintiff.
plaintiff. Okay? And according to the defendant, the plaintiff was minor at the relevant
Student, not a minor. Student.
Was a student at the relevant point of
And
time.
his father had purchased in the name because he was an employee of Tisco, so he was in government quarter, therefore he had
purchased it in the name of his son.
And by birth I am residing there.
And by birth he is residing there. So therefore, even if your best case is taken into consideration that that father was the true owner of the property, then also how does the defendant acquire any title or right over that property?
My contention was whether if I get into the entire deal with the entire judgment of the learned trial court, which I to a limited extent, learned trial court had categorically held the fact that I was not a licensee. I am not a licensee of that
But
land.
has the court held that you are the co-owner of the property?
No, owner of the property has, but it has held.
If you are not a co-owner of the property, anybody can seek your eviction at any point of time. You can just claim adverse possession.
No, if I claim adverse possession or possession first, that I can claim adverse possession against an owner.
That's right.
He is not.
What is it to show that you are the co-owner of the property?
The fact is the plaintiff is himself not the owner of the land.
Plaintiff's father was the owner of the land.
He cannot be
because
he cannot.
You see, the property was standing in the name of the plaintiff.
Property in the Khatian, the property.
No, property by virtue of sale deed stood in the name of the plaintiff. Nobody has challenged that sale deed.
Agreed.
Right? Now, when that sale deed is not under challenge, now you are claiming that it's a Benami property in his name?
I am not claiming that since the Sikmidar land.
You cannot, you see, this is something, you are not challenging the sale deed. Nor would you challenge the sale deed because you are also claiming under the same sale deed.
I agree, I bow down to that fact.
Then what is your title over the property?
I was not a licensee.
Whatever he is.
So my contention
licensee means what? What is the meaning of a licensee?
You permit me to do a certain thing, you permit me to do by virtue of section 52 of Indian Inspector Act, you permit me to do a certain thing or you do not permit me to do
But the person, you become a licensee the moment you get the license to enter into the premises.
Exactly.
You are permitted to enter into the premises.
Exactly.
Irrespective of your ownership.
Irrespective of your ownership, but the person.
So where is your title?
The person who grants me license does not have the title. This is my contention.
We'll see that.
This is my contention. This is the only thing I am happy on this point minus. If the person, because it's a finding of reversal.
That's right.
Page 11, the internal page 11, page 14, learned trial court has found that defendant is not a licensee, and at page 19, the issue of Sikmidar has been, which has been reversed.
read this?
Please, please.
Page number 9
Lovely.
of the appellate court statement.
Coming to the
Yes, that's the dominant question.
yes, coming to the other.
The dominant question. Thus the dominant question for determination.
Thus, the dominant question was licensee under the printer is answered in affirmative. This is poor. Answer: Exhibit 3 has successfully proved that he is the owner of the property and admitted the constructive portion of a portion of property. One room has been described in the schedule. To take knock over the same shall be considered a license under the same.
So this finding that he was a licensee has been upheld.
No, it has been reversed. My contention was there was minus. Kindly use page 40.
Yes.
Page 40, internal page 11.
Page number?
40.
Let us see the findings one by one. Just a moment.
Just I'll go. I'll tell you.
You have the issues here
Yes.
at
Yes,
page
ma'am.
number 5.
Yeah,
Right?
trial courts order.
Trial court
Trial
statute.
court order.
Page number 5.
Yes, my lords.
Now the issue, the core issue would be whether
Three.
the defendant allowed.
3. Whether the defendant is a licensee and is in occupation of sub property or not.
Okay. And this 6 also
Yes, my lords.
allowed
Chatilal,
Chatilal
Chatilal
to live with him
illegally or not.
illegally. Right?
Yes,
What is the answer to issue number 1?
issue number
Issue
3?
number 3.
Yeah, page that was abstractly bringing it to page 39 and 40. Page 39, issue number 3.
Yes.
Maybe.
Yes.
Issue 3 is the main issue of this case, hence taken first for the consideration. Plaintiff has filed the present suit for eviction. PW1, Boreshwan is one of the plaintiff in this case. In his court information, he has simply repeated the plain story that the defendant is closely related to me and he has dire need of residential accommodation. As such, defendant approached him his back on. An approach made by him out of sympathy, I allowed the defendant to reside in the suit premise. The defendant in occupation of the suit as a licensee under him. Recently, he came to know defendant has legally, without my consent, allowed one Chotelad to live with the defendant in the suit premise. Due to the aforesaid fact, the defendant, he does not like to allow defendant to continue with the occupation of the suit premise as a licensee under him. He therefore, on 13/1/10, sent a notice through a lawyer revoking the license of the defendant and asking him defendant to vacate and deliver the vacant position of the suit premise. But after the service of notice, the defendant has not vacated the premise nor replied to the same. Therefore, he has filed the suit for recovery of possession of the suit premise from evicting the defendant thereon. Therefrom, the defendant on the receipt of the said notice left the suit premise along with Chotelad, keeping the suit premise residing elsewhere. The suit premise belongs to him and he is the owner of the suit premise and defendant in the occupation of the suit premise as licensee under him. As he has already revoked the license of the defendant, as such is entitled to recovery of possession of the suit premise. In para 21, he has stated his brother's name is Mataram Sharan. In para 23, he denied that disputed property is his joint owner and is a fact filed a false case. Defendant is named Rajesh Prasad, alias Rajesh Prasad. Let me clear that defendant is a close relative of the plaintiff. Defendant is a nephew of the plaintiff. Is admitted the plaintiff that Matarajan is the brother of Rajesh Prasad and father name is Matalal Sharan, Mata Sharan. I have evidence of Rajesh's nephew lived with 10 to 12 years, where plaintiff has filed against Kamla for vacating the suit which is pending in the court. He has no proof that defendant has been living for the 10 to 12 years. From the above discussion, it cannot be said the defendant is a licensee of the plaintiff.
And the appellate court has said that
He is a licensee. This minor
he is a licensee. Heard the learned counsel appealing on behalf of the appellant. This appeal has been filed against the judgment and decree dated 27 June 2020, in bracket decree signed on 7/7/2020, passed by learned Principal District Judge East Singhbum at Jamshedpur in Civil Appeal number 60 of 2019, whereby the learned First Appellate Court has been pleased to allow the appeal preferred by the plaintiffs and has been pleased to set aside the judgment and decree dated 22/6/2019, in bracket decree signed on 26/6/2019, passed by learned
Additional civil judge junior division.
additional
Civil judge junior division.
additional civil judge junior division, Singhbum East Jamshedpur. The learned counsel for the appellant submits that the suit was dismissed, the first appeal was allowed, and consequently the defendant is the appellant before this court. He has also submitted that originally there were only one plaintiff and one defendant. The plaintiff was Shri Parshuram Prasad and the defendant was Rajesh Prasad. And both the parties has been later on substituted in the proceedings. The learned counsel has submitted that the learned trial court that has submitted that the plaintiff claimed that the defendant was a licensee in the suit property. Although the defendant is closely related to the plaintiff, inasmuch as the defendant is the own nephew of the plaintiff. He submits that the defendant was living on the suit property as his own right since birth, and therefore the property, and therefore he also had right title, interest and possession with respect to the suit property, and he cannot be termed as a licensee. The learned counsel submits that the learned trial court has returned a finding that the defendant is not a licensee while deciding issue number 3, but that finding has been reversed by the learned first appellate. The learned counsel has further submitted that the suit property was purchased by the father of the plaintiff in the name of the plaintiff. At the relevant point of time, the father of the plaintiff was an employee of DISCO, and therefore the plaintiff did not have exclusive title, right title with respect to the suit property. He submits that this aspect of the matter has not been properly considered by the learned first appellate court while reversing the finding, and therefore a substantial question of law be framed and the appeal be held. After hearing the learned counsel for the appellant, it was the specific case of the plaintiff that this court finds that it was a specific case of the plaintiff that the defendant is closely related to the plaintiff, and the defendant was in dire need of residential accommodation, and therefore defendant approached him about 10 years back and on approach the plaintiff allowed the defendant to reside in the suit premises. The defendant remained in occupation of the suit premises as a licensee under the plaintiff. The cause of action arose when the when the plaintiff came to know that defendant was illegally and without his consent allowed one Chotelal to live with the defendant in the suit premises. Due to the aforesaid act, the plaintiff desired to discontinue the occupation of the premises by the defendant, who was occupying the premises as a licensee. And ultimately, a legal notice was issued to the defendant on 13/1/2010, revoking the license and asking the defendant to vacate the suit premises. And thereafter, when the defendant did not vacate the suit premises, the suit for eviction was filed. It was also asserted that the defendant, on receipt of the notice, left the premises along with Chotelal, keeping the suit premises to him, and was residing elsewhere. And therefore, the plaintiff filed the suit seeking a decree of recovery of possession from the defendant. It is not in dispute that the defendant is the own nephew of the plaintiff. The learned trial court framed as many as
9 issues.
9 issues, but considering the arguments advanced on behalf of the appellant, the core issue is issue number 3.
3 and 6. 6 has also been decided in favor of the defendant.
By both the courts. This Chotelal was living.
Should not. Issue number 8. It's not 6. 8.
Issue number 3 and
8.
8.
With respect to issue number 6 members,
Issue number, you have just argued on the point of license.
no, I'm also arguing to point of
Sigvida.
This one. Yes.
Issue number 3 and 8.
This one.
The learned counsel has also submitted that the suit property originally belonged to
Rakhal
Rakhal
Sardar.
Sardar, who was a Sikridar,
Yes,
within bracket under Rayya, and he had no right to execute sale deed with respect to the suit property. The plaintiff was claiming the suit property by virtue of a registered sale deed, and that sale deed itself was
the transfer itself was not.
the transfer itself was not in accordance with law. The finding of the learned trial court in connection with issue number
8 is a parallel.
issue number 3 and 8 is at paragraph 15 and 19, which are quoted as under. The learned first appellate court framed the point of determination. They took up the same issues or separately framed the point.
Similar paragraph.
Okay. In paragraph 12 as under.
That signal issue, point of determination was not framed, but yes, concept to reverse the thing.
The learned first appellate court recorded that the incidental question to the dominant question was the issue raised as to whether the defendant was a co-owner for the reason that the property was acquired by his grandfather Ram Pukar Prasad, who died leaving behind 2 sons and a daughter, and his father and the plaintiff were own brothers, and therefore whether he was the legal heir of Ram Pukar Prasad and was occupying the suit premises in that capacity. And the other incidental question which was posed was with regard to the right of Sikmidar Rayyat as to whether such Sikmidar Rayyat was entitled to allow any person to live in the premises as licensee and to evict such licensee from the property. The learned first appellate court referred to the registered sale deed executed in favor of the plaintiff way back in the year 1968, and the claim of the defendant that the plaintiff was a benamdar as the purchaser was his father. The court considered Exhibit 3, which showed that the deed was executed on 30/12/1968 by widow of Hirak Thakur in favor of Parshuram Prasad, son of Parshuram Prasad the plaintiff. The sale deed showed that the occupation of the purchaser was shown to be a student, but nowhere contained any recital that the purchaser was a minor at the relevant point of time, or that father of the purchaser had paid the consideration amount. The learned court recorded that there is presumption in respect of immovable property, and the presumption is that the recorded owner shall be considered to be the real owner. And if anybody wants to rebut this presumption, he has to come up with evidence to show that the recorded owner was not the real owner of the property. The court recorded that apparently there was nothing on record to show that the purchaser, that is the original plaintiff, was a minor at the relevant point of time, and even the even if the age is taken into consideration, it would transpire that on the date of purchase of property in the year 1968, the plaintiff was about 26 years of age. The plaintiff ये 26 years के father का age है.
The age of the
Plaintiff. The plaintiff had retired in the year 2005 and was a TISCO employee and was appointed in TISCO in the year 1971. That's right. The court also recorded that there was no evidence on record to show that the presumption that the plaintiff being the owner of the property was rebutted. But the court also recorded that the defendant had a case, had also asserted that the property was partitioned amongst 2 brothers and sisters, but he failed to come up with any with any evidence, much less oral evidence, any evidence, oral or documentary, with respect to the partition between the plaintiff, with respect to the partition as claimed. The court ultimately held that, in absence of any evidence to the contrary, the court had to conclude that the plaintiff was the recorded owner of the property by virtue of the registered sale deed in the year 1968. And merely because the sister or brother was residing in the portion of the property, that cannot lead to a conclusion that the property was a joint family property. And ultimately held that the defendant was a licensee under the plaintiff, and that the plaintiff was the owner of the property, and that the defendant was in constructive possession of a portion of the property, that is one room, which was described in the schedule of the claim by putting lock over the same. The court held that these aspects of the matter was not considered by the learned trial court while recording the finding, and ultimately reversed the finding of the learned trial court. The learned first appellate court also held that there was nothing to show that the defendant was the co-owner of the sued property. With respect to the right of Sikmidar, the court was of the view that the property involved in this case was a house and not the Rayati land. And was not an agricultural land. And held that the right of the plaintiff cannot be diluted simply for the reason that in the remarks column there is an entry of Sikmidar. And even if such a question would arise, it is for the superior landlord to evict the Sikmidar or the heirs. But such a plea is cannot be taken by a licensee. And this question does not have any significance and does not favor the defendant in any manner. This court finds that the learned first appellate court has rightly appreciated the materials on record and has reversed the finding of the learned trial court. There being no substantial question of law involved in this case, this appeal is accordingly dismissed.
Grateful for appreciating.
But you argue well. I always see that. You are quite well prepared and keep the court engaged. Yeah, Prateek, have you given your name in the list? इनका नाम क्यों नहीं दिया? ये करते हैं सिविल मैटर्स कभी कभी अच्छा भी करते हैं. आपने दिया है लिस्ट यहाँ पर? क्यों नहीं दिया लिस्ट? Who did I ask? I asked Mr. Manjur Prasad to give me a list. नहीं डालो इसमें. ये दिए हैं क्या लिस्ट? इसमें इनका नाम डालो. दीजिए चलो. अपना नाम को नंबर डालिए. I propose to appoint number of amicus in old cases. Irrespective of counsels appearing.
Item 24, second appeal 91 of 1022.
Plaintiffs were second appeal managers concurrent filing of both the courts. The suit was filed for delegation of right title interest. The plaintiffs claiming title on the basis of being a legal heir of a recorded tenant. the defendants, madam, they are claiming title that the original recorded tenant had sold the property by way of a registered deed way back in 1930. And thereafter, their name was also
What
being-
remains?
you know,
The recorded tenant had already sold the property. It's a registered deed, है ना? फिर क्या है इसमें? चलिए.
Only by one submission maybe got matter. There was the description of property in the deed and the schedule of the claim was different. Although there's a finding to that effect.
Now you help me. Tell me the issues and from where do I pick up the foundational facts?
From the appellate course.
Okay. Okay.
The issues are at paragraph number 9.
Yes. Okay. Which is that exhibit? Stated. Exhibit 1 is the Aris Khatyan. Exhibit 2 is the Banda Pacha. This is filed by the plaintiff.
Exhibit A.
Exhibit A is the sale deed.
Yes.
Okay.
Rent receipts have also been brought on according to C to C.
By the defendant. When is the issue regarding identity of property? Is there any different issue framed? Oh, it's issue number 6. Nothing else. I don't find it here regarding identity of property.
Submission was made, madam, but CS Tata since the Aris Khatya was there was some mismatch, but that is essentially the
That has been taken care of while deciding the
paragraph number 19.
para 19.
And one more madam's objection that the learned appellate court has said that there's a presumption because the document is 30 years old. It will only be
The
recorded.
registered document is sufficient.
Yes.
There is a presumption of
But it is a
correctness of registered document.
rebuttable.
Rebuttable, but you have failed to rebut.
Yes.
Okay, heard the learned counsel appealing on behalf of the appellant. This appeal has been filed against the judgment dated 34/22 within bracket decree signed on 12/5/22 passed by learned district judge Roman 2 Kuti in civil appeal number 53 of 2012, whereby the appeal preferred by the plaintiffs. One plaintiff or
It is
plaintiffs
3 pages.
has been dismissed and the judgment dated 29/5/2012 within bracket decree signed on 13/6/2012 passed by the learned Munsif Kuti entitled suit number 8 of 2011 dismissing the suit has been affirmed. The learned counsel for the appellant has submitted that though there are concurrent findings recorded by both the courts, but the judgments are perverse. He has submitted that the learned First Appellate Court has wrongly referred to the registered sale deed dated 6/3/1930 as 30 years old document. It was less than that.
More than that.
More
Seeing
than
that it's a rebuttable presumption, so
Okay.
there cannot be.
He submits that it is just a rebuttable presumption and the sale cannot be taken as a gospel truth. He has further submitted that there was discrepancy in connection with the identity of the property when compared with the property mentioned in the registered deed of 1930 and the suit property. He submits that these aspects, having not been considered, a substantial question of law be framed and decided. After hearing the learned counsel for the appellant, this court finds that the suit was filed seeking a declaration of right, title, interest and confirmation of possession of the plaintiff over the suit land, and in the alternative a decree for recovery of possession of the plaintiff, and plaintiff be put in khas possession of the suit property, and the defendants be permanently restrained from making any changes in the suit property. The specific case of the plaintiff was that plaintiff was a descendant of the recorded tenant. The full stop. The record of rights in respect of revisional service settlement khata number 31.
Yes, ma'am.
Khata number 31 of village
Gugu.
Gugu, PS Kadra, district Ranchi, now Futi, stood recorded in the name of
Potma.
Potna Urao, and the schedule of the property was RS plot number 488, measuring an area of 0.94 acres, falling under this khata, which was mentioned in Schedule B of the plate. The plaintiff had given the genealogy and claimed to be the plaintiffs had given the genealogy and claimed to be the descendants of the recorded tenant. The cause of action arose when the defendants, in the first week of June 2010, when the defendant threatened to dispossess the plaintiff. As per the written statement, the defendant number 2 was the deputy commissioner.
Yes.
Deputy commissioner, the case was contested by all the defendants except the defendant number 2. It was asserted that there was no cause of action. It was a specific case of the defendants that the recorded tenant Potnu Ram had no concern with the suit land as he had sold the property by registered deed on 6/3/1930. the father of the plaintiff number 1 to the father of the plaintiff number 1. And it was also the case of the defendants that they were in peaceful possession of the suit property since 1930. And their name was also mutated in the revenue records. And they were paying rent after vesting of Jamindari also. Their name was also entered in Register 2 of the state government. The defendant also gave the genealogy with respect to their family. It was further case of the defendant that the sale deed was registered on 6/3/1930 and the RS Khatian was published on 10th of June 1971, that is after completion of 15 months. Before the publication of Khatian under section 83(2) of the Churanakpur Tenancy Act, draft record of right under section 83(1) of the CNT Act was published. The khata number and the plot number of the suit land during that is CS record of right in respect of the suit land was 19 and CS plot number 267 and the area was 0.97 acres. It was asserted that both the record of rights were the same. The sale deed corresponded to CS plot and khata, and there was no confusion about the suit land, since the plot and khata of the suit land as recorded in CS and RS has been mentioned specifically in the deed of sale dated 6/3/1930. It was also stated that is enough. The sale deed, both the parties had adduced oral and documentary evidence. The defendant had specifically exhibited the sale deed dated 5/3/1930 as Exhibit A, and the rent receipts were also exhibited as Exhibit C to C/5. Further, an order of proceeding under Section 144 CRPC was also exhibited as Exhibit B, wherein the possession of the defendant was shown.
Yes, ma'am. In the 144.
Yes. The trial court had framed the following issues. The plea of adverse possession of the plaintiff was, who claimed adverse possession? The plaintiff.
Yes.
The plea of adverse possession of the plaintiff was declined, and the right title, interest and possession of the court found that the defendant was having the right title, interest and possession with respect to the suit property, primarily on the basis of the registered sale deed of the year 1930 and also the other two exhibits produced by the defendants. The learned first appellate court also considered the materials on record and recorded the finding in paragraph 19 of the appellate court's judgment. '19 and 20. this court finds that both the courts have meticulously scrutinized the materials on record and have dismissed the suit filed by the plaintiff and decided the case in favor of the defendants, primarily basing on the registered sale deed of the 1930s coupled with the document showing possession. There being no substantial question of law involved in this case, this appeal is accordingly dismissed.
Possible choice
Can't. Difficult.
Item 25, second appeal 98 of 2022.
Yes.
The plaintiff appellant and this is the judgment entity of the accommodation and the concurrent finding which has been passed by the
What was the suit for?
suit for us is the declaration of right title and interest over the house and the land of 28 decimal squares in the village Tilaiya, district Kodarma. And the second prayer in the court was to declare that the divisional survey entry with respect to the sold property in favor of Ram, Gopal Nath and Chotu Ram are wrongly and not binding upon the plaintiff. There are two consequences of that. For declaration of right and interest with respect to the house and the land. And for for declaration, for the declaration that is entry made in the divisional survey record of right, which was in the year 1967.
The suit was held to be barred by limitation.
No.
Let's see. What were the issues framed?
Issues were
What was the case of the defendant?
defendant, they say plus the main defendant in whose favor the entry was recorded, defendant number 1 and 2, they never appeared. They never appeared in the lower court, so therefore it was the next point against them. So only defendant number 3 appears and he files his written statement and he says that he being the Karta of the family has paid 5 lakhs 73,000 which was due to be paid for the Dayanand Badani Millers who sold the property to me. It has a little checkered history, my lord, permit. I will just in a nutshell, my lord, I'll narrate the case of the defendant, plaintiff and the defendant. But the case of the plaintiff is that she bought a property by virtue of sale deed from Dayanand Badani in the year 1962.
Just a minute. 1962.
12 to 1962.
12 to 1962. Sale deed.
Sale deed. She got
In
it
name of plaintiff.
in the name of the plaintiff.
What
Now,
was the original owner?
original owner Millers.
Yes. What is Dayanand Bhadani?
Dayanand Badani.
Then what happened?
Consequently, Millers, after the purchase of the land, because house was also there in the property, she came into the position, she continued to be into the position of the property. And in the year 1967, there was a survey, provisional survey in that area. And in the survey settlement, the khata number, plot number were also changed. And consequently, in the divisional survey, the name of Chotu Ram and Ram Gopal Nath name was appeared, who were defendant number 1 and 2 in this suit.
Name of
Chotu Ram
Chotu Ram and
Ram Gopal Nath. Ram Gopal Nath is the father of the defendant number 1 and defendant number 2. And Chotu Ram is the defendant number 2.
Father of dependent number 1 and 2, and Chotu Ram is dependent number 2. Who is dependent number 1?
Defendant number A, defendant number 1. Lot of substitution in this case. Here for Sadanand Ram.
Sadanand Ram. Just a moment.
1996 is Sadanand Ram.
Sadanand
Ram. And Champa Devi.
Ram was dependent number 1.
Okay. Consequently, what had happened?
Just a moment. The learned counsel for the appellant has submitted that the plaintiff is the appellant before this court and has lost in both the courts.
Good.
He submits that the plaintiff claimed the property by virtue of sale deed executed by Dayanand Thadani as back as on 12/2/1962, and thereafter the plaintiff came in possession of the suit property. He submits that in the year 1967 there was this revisional survey and appropriate khata number and plot number was allocated to the property purchased by the plaintiff. However, in the revision survey, the property stood recorded in the name of Chotu Ram and Ram Gopal Nath. Ram Gopal Nath was the father of Chotu Ram. He submits that the plaintiff number 1, the dependent number 1 is Sadanand Ram, who is another son of Ram Gopal Nath, and Chotu Ram was dependent number 2 in the suit. He submits that dependent number 1 and 2 never contested the suit and the proceeding was ex parte against them. The suit was contested by dependent number 3. क्या किस कैपेसिटी में क्लेम किया प्रॉपर्टी?
क्योंकि उन्होंने जो दयानंद वधानी थे वो लॉन्ग बैक मॉर्गेज लिए थे इसी प्रॉपर्टी को लेके फ्रॉम LIC. सो LIC से वो मॉर्गेज लिए थे प्रॉपर्टी को. तो देयर वाज अ प्रोसीडिंग इन द बॉम्बे हाई कोर्ट ड्यूरिंग दैट टाइम फॉर द रिकवरी ऑफ मनी बाय द ओरिजिनल टाइटलशिप इन द ओरिजिनल जुरिडिक्शन बाय द LIC.
That's right.
So consequently, what had happened in order to recovery was there done because preliminary decree was passed by the
That's
Honorable Bombay High Court for the purpose of recovery of the amount.
The property must have been sold.
Yes.
When? Date of sale. Date of sale.
बता रहे हो बता रहे. ये पैराग्राफ 19 of the written statement में ही है.
Date of sale बताइए.
30/6/1966. The commissioner granted sale certificate in favor of LIC, and the sale was.
What is the date of mortgage?
Mortgage was. In the year 1954, Chotu Ram Madani took loan of rupees 2,71,838 from LIC of India.
Chotu Ram Bhadani had taken loan.
Yes.
और दयानंद Bhadani. दयानंद छोटू राम, अच्छा छोटू राम is son of दयानंद Bhadani.
Yes.
नहीं, छोटू राम तो आपने बताया राम गोपाल नाथ के.
हम बता रहे हो. ये जो जमीन खरीदा गया है एग्जिबिट अगर 3 देखा जाए दैट इज द सेल डीड. बहुत सारा कंफ्यूजन है इस केस में, क्योंकि चक्कर हिस्ट्री बहुत ज्यादा है इसमें.
ज्यादा नहीं है, सजाने की बात है. इतना मुश्किल नहीं है. अभी तो आपने केस की हिस्ट्री पढ़ी नहीं है 5 जनरेशन की.
पढ़ी है, मतलब इट्स अ वेरी लॉन्ग चेकर्ड हिस्ट्री, बहुत लंबा चेकर्ड हिस्ट्री है। लोन हुआ है, सेल डीड एग्जीक्यूट हो गया है, उसके बाद में एग्जीक्यूशन प्रोसीडिंग हुआ है, एंड इन एग्जीक्यूशन प्रोसीडिंग डिफेंडेंट नंबर 3 से आई हैव पेड द अमाउंट, सो देयरफॉर आई एम द ओनर ऑफ द प्रॉपर्टी।
कॉम्प्रोमाइज हो गया।
कॉम्प्रोमाइज नहीं, क्योंकि हम 5 लाख रुपए दे दिए जो कि पैसा उस समय से लिया गया था, इसीलिए चूंकि और जो मेरा सेल डीड है उसको बिल्कुल ही कंसीडर नहीं किया गया कि हम वाइल सेल डीड आई एम इनटू द
अच्छा
पोजीशन।
सुनिए ना, पहले तो ये डिपेंडेंट नंबर 3 का रिलेशन बताइए।
बताइए
हाउ इज डिपेंडेंट नंबर 3 रिलेटेड टू दिस प्रॉपर्टी?
इसी से बता देते हैं, लेटर शॉप पे जो जजमेंट है वो इसी से बता देते हैं। ये जो अगर जजमेंट अगर देखा जाए तो जजमेंट देखा जाए इससे क्लियर हो जाएगा, बहुत सारी बात क्लियर हो जाएगा। जजमेंट का पेज
ये 62 का दयानंद भदानी ने नहीं सेल डीड किया है, छट्टू राम
हो सकता है यहाँ पर
यहाँ जहाँ लिखे है ना 12 to 1962 पंकज जी, the sale deed was executed by छट्टू राम भदानी। आप फैक्ट्स में बहुत कंफ्यूज है, फैक्ट्स सजा के लेके आए।
हम चूंकि एक्चुअली में यहाँ पर क्या हुआ, आई हैव बीन आई शुड नॉट से आई हैव बीन रनिंग अराउंड सो मच टुडे, सो देयरफॉर देयर आर सो मेनी नोटिस व्हिच हैव बीन डन एंड दीस आर इंटरमिंगल्ड।
आप इसको सरियाइए।
हाँ,
कैसे सरियाइएगा? लेफ्ट हैंड साइड में प्लेंटिफ का केस पूरा लिखिएगा, राइट हैंड साइड में पूरा का पूरा डिफेंडेंट का केस लिखिएगा, और डेट वाइज रहेगा। डेट ऑफ मॉर्गेज इज इम्पोर्टेंट, बिकॉज सेल अगर हो रहा है विच इज ऑलरेडी मॉर्गेज प्रॉपर्टी का जब भी सेल होता है इट इज सब्जेक्ट टू मॉर्गेज, एंड देन यू विल हैव अ इंफीरियर राइट इफ देयर आर टू थिंग्स। एक है कि सेल के बाद मॉर्गेज हो गया, यू नेवर नो, आपको सेल करने के बाद मॉर्गेज हो गया, दिस इज वन एस्पेक्ट। एक होता है आपको सेल करने के पहले मॉर्गेज था, आपको मॉर्गेज प्रॉपर्टी बेच दिया, दोनों में फर्क होगा।
मॉर्गेज करने के बाद
हाँ तो फर्क है, बहुत फर्क है। मॉर्गेज करने के बाद अगर छट्टू लाल ने आपके नाम से कोई सेल डीड एग्जीक्यूट कर दिया है तो उसका क्या वैल्यू? इट इज सब्जेक्ट टू मॉर्गेज।
It is subject to mortgage and consequently, and my lord has actually pointed out, consequently my lord यहाँ पर दो बीच में आ रहा है, एक LIC ने सेल डीड एग्जीक्यूट कर दिया, लेकिन thereupon in हजारीबाग में there was an execution case filed by the LIC, and in that execution proceeding ये जो डिफेंडेंट नंबर थे इन्होंने पेमेंट कर दिया पैसा। जब इन्होंने पेमेंट कर दिया तो मेरा जो 62 का जो डीड है that will
कैसे, जब ऑलरेडी सेल कर दिया तो कैसे उसको सब्सर्व कर?
तो सेल कर दिया 62 में, but by way of compromise the sale deed was never challenged, LIC का sale deed was
The
never
purchaser was a party to that compromise.
ये he was a कर्ता, defendant number 3 was a कर्ता of the family।
इसका फैक्ट ठीक से सजाइए,
कर
कल रखें, फैक्ट ठीक से सजा के लेके आएंगे, है ना? After some argument, the legal counsel for the appellant submits that the matter be posted to me.
जो ऊपर लिखे हैं वो रहेगा।
नहीं रहेगा, जो लिखा है उसको रखने से कोई फायदा नहीं, आप लेके आइए,
हम कर लेंगे
पूरा सीक्वेंस बना के लेके
बना
आइए।
लेंगे।
Item
आपको
26.
अपने ही पता लग जाएगा आपका केस में कितना दम है। हम इस रिकॉर्ड को नहीं पढ़े,
नहीं, वो-
आज एक तो पार्टनर मैटर चल रहा है ना, बस स्टाफ में से भी नहीं।
Item 26, second appeal 200 of 2022.
There's nothing in the
Essay number 200 of 2022.
Introduction only allow me. I am the original plaintiff. I filed a suit for declaration that the two daughters of my cousin, that means my cousin sisters, they had executed certain two sale deeds. Those were declaration was sought as against them. Now the trial court, after discussing everything, it dismisses my suit. It dismisses my suit by judgment and decree dated this would be important because ultimately my first appeal has been dismissed on the ground of limitation that it was barred by limitation. So the suit was dismissed on 27th of February 2019.
Okay. What is the date of sale deed?
The decree is
Sale deed.
sale deed is 2007.
Suit was filed when?
It was in 2007 itself. No, it was the suit was not dismissed on the ground of limitation. The appeal was dismissed on the ground of limitation. The trial court in detail it discusses and it holds that the daughters have the right to transfer the property. This was the finding of the trial. And we were claiming that they were married and after marriage they had gone to their houses and we had ousted them from the property. And basically it was in the nature of adverse possession, what we were claiming. So we said that because they did not have any right on the property and therefore
How much was the delay in filing the appeal?
a delay was 2.5 years. So during that period, $860 days. But you know, Chip,
I
one
have
thing.
considered it fully. Where is the question of any substantial question of law on this? When the appeal itself was barred by limitation.
Then the question would be as to whether the appellate court has failed to consider the matter under Section 5. If there may be
Under
cases,
Section 5, they have considered and dismissed your application seeking.
but if it is ultimately, there may be cases where it is found that the appellate court's order dismissing my application under Section 5 is actually not proper.
Let us
Absolutely.
see.
Then
There is nothing.
here it has given reason.
It has given sound reasons. Everything it has mentioned. That there was complete indifference from your end.
It says that the original plaintiffs, we were the original descendants of the original plaintiff, they were substituted during the suit stage itself, and our advocate, he was taking steps, and then we cannot say now that we were unaware about the
Yes.
ultimate
Judgment.
order.
Because you were already represented.
Yes, this was the plea.
Now help me with the appellate court's judgment. Where is the finding?
Yes. The findings it actually starts from para 6, but
Now let us see the ground for condonation of delay, para 2.
I'll read. It is stated that the original plaintiff who were predecessor of the present appellants filed titled partition suit number 190/2007, although it should not have been partition suit, should have been only
Title suit.
190 of 2007, but the present appellants have no knowledge about the same, neither they have any knowledge about the land, so neither they had any knowledge about the suit nor the fact that the same had been dismissed. It is further stated that sometime in the month of February 2000, Sri S.K. Banerjee, advocate through a messenger, informed the appellant number 1A and 1C to meet him in connection with the above suit, and in pursuant of the same, both contacted him in last week of February. It would be 2020 here. February 2000 it is mentioned.
2000?
It would be 20. Because the suit itself was
That's
dismissed in the year 2019. February 2020, whereupon they were informed that their predecessor, that is, original plaintiff, filed title partition suit number 190 of 2007 against the defendants, which was being conducted by a senior advocate named Gaur Kishore Ganguly, who died after a prolonged illness, and as such he could not inform them about the fate of the said suit. It is further stated that Sri S.K. Banerjee, advocate, informed the appellant that the
Said suit had been dismissed against them and an appeal had to be filed to protect their interests and demanded his outstanding bills and cost of procuring certified copy of the judgment. It is further stated that both of them promised to come after 15-20 days, but a lockdown was imposed in the third week of March 2020 in view of outbreak of coronavirus. Therefore, they did not make any attempt to get the appeal filed either in the late 2020 or early 2021. In the month of June, July 2021, they came to learn about the appeal being could be filed and decided to consult Sri S.K. Banerjee, advocate, who revealed that instead of waiting for the certified copy of the judgment and decree, the same would be downloaded from
The period had expired prior to coronavirus.
Yes. Yes, that is. But that period at least ought to have been excluded. That could not have been
That's right,
counted
but
because
you see the point of exclusion of that period.
but before that, you
Before that,
it happened.
before that, it had expired.
CIS and appeal could be filed. Therefore, the present appeal was filed without further delay on 7/8/2021 and prayed to condone the delay of 860 days in filing the present appeal in the interest of justice. So the delay would actually be approximately 1 year, not 860 days. It would be approximately 1 year.
Let us see the finding.
Yes. That main finding is what you would get after. Para 13. On careful examination of the case record, it is apparent that after the demise of plaintiff number 1, his legal heirs were brought in record. By the order dated 3/7/2018, the record further suggests that plaintiff number 2 died on 11/11/2013 and his legal heirs were brought in record by the order dated 5/1/2015. The plaintiff number 3 also died during the pendency of the suit, but the substitution application was dismissed and the suit was abated for plaintiff number 3 by the order dated 5/2/2018. Needless to mention that after getting substituted in place of their respective deceased plaintiffs, their legal heirs were appearing before the court and filing attendance through their respective counsel. Even on the date of judgment, on 27/2/2019, the parties filed their attendance through their respective counsel. Now I come to the first application under Section 5 of Limitation Act dated 5/8/2021. Para 2 of the said application states that present applicants had no knowledge about the suit. Neither they had any knowledge about the land.
Same thing is being repeated.
Then I'll skip. Your Lordship, there.
So the contention of the learned counsel that they were not aware is not correct.
Your Lordship is reading the
Last sentence of paragraph 14.
and then page 33, last 4 lines, Your Lordship. It is also not clear as to why information with regard to passing of judgment was supplied to the applicant number 1A and 1C after more than 1 year. It appears that the said fact has been introduced for the first time just to show the sufficient cause, but the fact remains that the present appeal was filed on 7/8/2021, that is more than 2.5 years. Moreover, the certified copy of the judgment and decree was applied on 6/8/2021, which was prepared by the copying department on Samsung, and the same was filed. Therefore, it stands clear that the action taken by the applicant after a long delay of 2.5 years, this court is aware the fact that while allowing the application under Section 5 of this court is to draw attention between delay and inordinate delay, it must be borne in mind that the sufficient cause is the condition precedent for exercise of discretion by the court for condoning delay. Now I would like to refer to para 7 of petition filed by section 5 of the Limitation Act, which says that the suit was prosecuting by original plaintiff and for about 8-9 years thereafter they died, though the appellants were substituted as legal heirs in their respective place, but they do not
So
have
absence
much.
of knowledge has been completely disbelieved by citing as to how the plaintiff has been conducting the proceedings.
That, what your lordship, my wakalatnama does not say that whether I had executed any wakalatnama. That does not say. But
You
then
have been
the
appearing, you have been
appellate court,
participating, you were substituted. What else is required?
the appellate court also goes on to discuss the matter on merit in para 18 also. That the matter even otherwise does not. So my only contention, your lordship, would be that the delay was not 2.5 years, it was wrongly mentioned because the COVID period was not considered, and the delay could have been at best 1 year, and because we did not have the knowledge about the suit, therefore we did not participate in we could not file appeal earlier. And that was a sufficient.
Does this COVID period is to be excluded even for those where the limitation had already expired?
No. It
So
only
here the
says.
limitation expired prior to.
It only says that that period would not be counted for the purpose of limitation. That period goes, but before that
It expires.
so the delay would be 1 year.
So physical running of time would be
1 year.
arrested.
No, it would be 1 year, not 2.5. That is, so it would. There was no inordinate delay. There would have been delay, but not inordinate. That is.
And on merits also he has dealt with.
Yes, it has discussed. In para 18 it has discussed what your lordship. Ultimately, my suit
Para
has,
18.
my appeal, yes, para 18. My appeal has been dismissed mainly on the ground of limitation. One question may arise, I must also disclose it fairly, that whether a second appeal would lie against an order where the first appellate court dismisses the first appeal only on the ground of limitation. In that, there was a.
Ultimately, a decree has to be drawn.
Because there was earlier judgment that ultimately the trial court decree, by dismissing the appeal, it ultimately merges with the trial court judgment and it is affirming the order passed by the trial. Therefore,
The suit was dismissed.
Suit was dismissed.
Okay. How the learned counsel appearing on behalf of the appellant? This appeal has been filed against the judgment dated 9/11/2022, passed in civil appeal number 11 of 2021, passed by learned Principal District Judge Dhanbad, whereby the judgment and decree dated 27/2/2019, within bracket decree signed on 7/3/2019, passed in. It's not a partition suit.
It was not. Your lordship would get the
partition suit.
your lordship would get the prayer in page 55 of the decree portion. Decree for declaration of right title interest of the plaintiff upon the land as described in Schedule A below, with a declaration that the alleged sale so and so 2007 executed by defendant number 5 and 6 in favor of defendant number 1 to 4 is a sham and collusive transaction conferring no right title interest upon the defendant number 1 to 4.
Arising out of title suit number 160 of 2007, 190 of 2007. The learned counsel has submitted that the first appeal has been dismissed on the ground of delay in filing the appeal by 2.5 years. He has submitted that the title suit was dismissed on by judgment dated 27/2/2019, and the appeal was filed on 7/8/2021. And in the meantime, there was COVID-19 situation. The learned counsel submits that if the period of COVID-19 situation is deducted, then the appeal was barred by approximately 1.5 years.
9 months to 10 months, because 3 months is granted for, I had 3 months. No,
1 month.
I had only 1 month.
1 month.
1 month. So
Was-
it would be approximately 1 year.
Was barred by about 1 year. But this aspect of the matter has not been properly considered by the learned first appellate court. He has also submitted that the learned first appellate court has also not properly considered the fact that the plaintiff appellant had also pleaded that he had no knowledge about the judgment, about the dismissal of the suit on 27/2/2019.
And it is only after the council informed me, then we.
And the plaintiff had come to know about the suit as well as the judgment only after one counsel had informed him about the matter. अबेट भी हो गया था ट्रायल कोर्ट में।
अबेट हुआ, लेकिन उसका इफेक्ट इस पर, उसमें कोई the court has not gone into question, both the courts, as against only one of the plaintiff.
After hearing the learned counsel for the appellant, this court finds that the title suit number 190 of 2007 was 80, sorry, the learned counsel has also submitted that the case arises out of a title suit and not title partition suit, and it has been wrongly mentioned. कहाँ पे लिखा है title?
Wrongly registered as title partition.
It was wrongly registered as title partition suit. However, from the perusal of the decree of the learned trial court, the cause title shows that it was registered as title suit number 190 of 2007. Top में ही है वो.
हाँ ठीक.
After hearing the counsel for the appellant, this court finds that the suit was filed seeking a declaration of right title interest of the plaintiff upon the land described in Schedule A, along with a declaration that the sale deed number 4419 of 2007, executed by defendant number 5 and 6 in favor of defendant number 1 to 4, was sham and collusive transaction and was not binding upon the plaintiff. A prayer for permanent injunction was also sought. The learned trial court had framed the suit was contested. The suit was contested.
Contested.
The trial court had framed the following issues for consideration, para 4 में है. The suit was contested and ultimately the sale deed bearing number 4419 dated 14/5/2007 was held to be valid. The prayer for adverse possession of the plaintiff was rejected and the suit was dismissed. By judgment in decree dated 27/2/2019, the appeal was filed on 7/8/21 and the appeal has been dismissed on refusing to condone delay in filing the appeal as the petition under Section 5 of the Limitation Act has been dismissed. While considering the petition under Section 5 of the Limitation Act, it was a specific case of the appellants that the original plaintiffs were the predecessor of the appellants who filed the suit, but the appellants had no knowledge about the same, nor they had any knowledge about the land. Nor they had any knowledge that the suit has been dismissed. It was only sometimes in the month of February 2000 that one advocate, Shri S.K. Banerjee, through a messenger informed the appellant number 1A and 1C to meet him in connection with the suit. And thereafter they contacted him in the last week of February 2020. February 2020. Contacted him in the last week of February 2020. And they came to know that the original plaintiffs had filed a suit against the defendants, which was being conducted by a senior advocate, namely Gaur Kishore Ganguly, who died after a prolonged illness. And as such, he could not inform them about the fate of the suit. And thereafter, the certified copy was obtained, and in the third week of March 2020, on account of outbreak of coronavirus, the appellants could not take any steps, and ultimately the step was taken in the month of June, July. ये आउटब्रेक का मतलब जो लिमिटेशन जो नहीं है वो कब से कब तक था? जून जुलाई में भी नहीं था. What was the period?
It was from
28.
I'll give the exact date. 20th of March 2022.
2022.
20th of March 2022.
22 तक नहीं. 22 तक नहीं.
22. It was extended to 20.
23.
By last order, ultimately.
2022.
Yes, but it was 20th of February 2022 or 20th of March. This is only I'll just 5 minutes here.
And thereafter, the appeal was filed on 7/8/21, seeking condonation with the petition seeking condonation of delay of 860 days. The prayer for condonation of delay was contested by the respondents before the first appellate court. And it was asserted that there was no sufficient ground for condonation of delay. It was also asserted that the plaintiff number 2, namely Mustaqim Mia Ansari,
Yes.
died on
Your Lordship, the date was, the date was 15/3/2020 to 28/2/2022. And the last, this order was passed in suo motu writ petition number 3 of 2020 and other analogous cases. And the date of the order is 10th of January 2020.
10/1/20,
22.
died on 11/11/23, and his legal years were brought on record by order dated 5/1/2015. Thereafter, plaintiff number 3, Safiq Ansari, also died on 5/5/2016, but the substitution application for bringing the legal years was filed on 14/7/2017. And the substitution petition with respect to plaintiff number 3 stood rejected by order dated 5/2018, and the suit was abated qua plaintiff number 3 within brackets Safiq Ansari. It was also stated that a substitution petition was also filed on 4/6/2016, stating that the plaintiff number 1, Abdul Mia Ansari, had died, and the said petition for substitution was allowed in his place by order dated 3/7/2018. It was further stated that the legal years of the deceased plaintiff number 1 and 2 were appearing and contesting the case, and also filed their attendance before the court, so they were aware about the pendency of the case, and therefore there was no sufficient explanation for condonation of delay. The learned court also took into consideration the order passed by the Honorable Supreme Court in suo motu writ petition civil number 3 of 2021, whereby it was ordered that the entire period of March 2020 to 28/2/2022 be excluded for the purposes of limitation. It has been mentioned in page 26.
28 to.
इसमें mentioned है.
मात्र 28/7/2022.
28 दो.
हाँ 28.
It is mentioned in the order also.
हाँ, ठीक.
It was further asserted by the defendants that the appellants were trying to establish sufficient cause by showing that the appellants had no knowledge about the suit filed by the original plaintiff, which was not correct. The learned court, after considering the case of both the parties on the point of condonation of delay under Section 5 of the Limitation Act, referred to the records and specifically recorded that in paragraph 13 that after device of plaintiff number 1, his legal heirs were brought on record by the order dated 3/7/2018. Plaintiff number 2 died on 11/11/2013 and his legal heirs were also brought on record by the order dated 5/1/2015. The plaintiff number 3 also died during the pendency of the case, but the substitution application was dismissed and the suit stood abated for plaintiff number 3 by the order dated 5/2018. And after the substitution at the stage of trial, the legal heirs were appearing before the court and filing their attendance to their respective counsels. And even on the date of the judgment on 27/2/2019, the parties filed their attendance to their respective counsels. The plea of the appellants that they had no knowledge about the suit and that they had no knowledge about the land and that they had no knowledge about the dismissal of the suit was rejected by the learned first appellate court, and the learned first appellate court was not satisfied with the was shown by the appellants in not taking appropriate steps within the stipulated time. The period for filing the appeal was only 30 days. 30 days. This court finds that the first appellate court has rejected the plea of the appellants that they had no knowledge about the suit and that they had no knowledge about the land and that they had no knowledge about the fact that the suit was dismissed by citing reasons based on the materials which were available before the learned trial court itself. The explanation was not satisfactory and hence the petition seeking condonation of delay was dismissed. This court finds that the learned first appellate court has applied its mind in connection with the petition seeking condonation of delay and has perused the records of the learned trial court while dismissing the appeal on the ground of limitation. There is no substantial question of law involved in this case, and accordingly, this appeal is hereby dismissed.
It is 30 days.
30 days.
30. That I was very.
90 days High Court.
हाँ.
वहाँ के लिए 30 days.
Sometimes I have confusion. I think that it is 60
It is mentioned
days.
in the order also.
हाँ.
From supplementary list for orders item 2, second appeal 84 of 2016.
Appellant is again absent. On the last day he was present. नहीं.
लेकिन उन्होंने फाइल कर दिया 22 और 26 के लिए, क्योंकि ऑलरेडी डायड है.
जब अपीलान नहीं है तो हम लोग क्या क्या करें, नोटिस कर देते हैं। ये इसमें तो आईए में तो नोटिस नहीं हुआ होगा ना रिगार्डिंग सब्स्टिट्यूशन ऑफ 8, 10, 13 and 18।
हाँ नोटिस नहीं हुआ बस फाइल ही हुआ
ये 15 चल रही
कब कौन मरा है? 1723 days। Who are you?
after the some respondent.
Yeah, number 17480/25. This petition has been filed seeking substitution of respondent number 8, 10, 13 and 18. 8, 10, 13 and 18. यही है ना?
8, 10, 13,
13 and 18. Issue notice to the proposed legal heirs and successors of the aforesaid respondents for which recusals be filed under speed post within a period of 2 weeks from today. The office note further reveals that the notices have been filed in connection with respondent number, deceased respondent number 22 and 26, pursuant to order dated 13th of August 2025, instead of their legal heirs, that is respondent number 22 within bracket 1 and 26 within bracket 1. The learned counsel for the appellant is permitted to make necessary corrections with respect to the recusal so filed, so that within a period of 15 days, so that the notices be dispatched to the respondent number 22.1 and 22.6.
Last time we got some file interested in
Sorry?
give a copy of petitions.
Preemptive. This order is also preemptive. Let a copy of this order be forwarded to, a soft copy of this order be forwarded to the counsel for the appellant to ensure compliance. अब बताइए.
Last time I requested to the counsel of the appellant to give a copy of the petition. They have not.
Counsel for the appellant is absent. Mr. So-and-so,
I'm Shikhar Gupta.
Mr. Shekhar, the office is directed to provide a soft copy of the मेमो ऑफ अपील विद एनक्लोजर, इसका तो स्कैनिंग होगा टू द aforesaid council at his following email ID. मेल ID दीजिए.
From tail list order verified item 9, first April 60 of 2019.
Certified copy का defect लगाया. We have filed a higher exemption. Earlier it was DFE dismissed for default on 3/2/20. Thereafter it has been restored on 1/8/25. It has come for the first time thereafter.
The certified copy is available where? Certified copy is available in which record?
It has been advanced.
FA number 58 of 19.
Yes, sir.
That case has been disposed of. Is it pending?
Well, that is this movie DFE was the CNP is pending.
उसका CNP pending.
जी.
कब है उसका CNP?
It is, you know, like a time would be given here because it has been DFE and it has unjust.
I think many of the cases have been disposed of. Yes? No.
DFE Miller, some are pending and some are DFE Miller. In this batch.
But
of
none
matters,
has been disposed of.
But in some of the cases, Miller, the order has been passed for that certified copy may not be.
That's right. You have one order. You have one order.
Yes.
But authentication fees is required to be filed.
Yes. That may.
What is the CNP number of this case?
This particular case.
No, the other one.
It is CNP.
FA relating to FA 58 of 2019.
1200/25. It's the filing number.
It's a filing number.
Yes. 1200/25.
IA number 615 of 2020 and FA number 60 of 2019. अवार्ड तो फाइल करना पड़ेगा ना. Award you have filed certified copy.
Photocopy.
Yes. The learned counsel for the appellant has submitted that the interlocutory application has been filed seeking exemption from filing the certified copy of the impugned judgment as a batch of cases arise out of the same impugned judgment, and the certified copy has already been filed in FA number 58 of 2019. Considering the interlocutory application, the appellant is exempted from filing the certified copy of the impugned judgment in this appeal. However, the authentication fee is required to be filed. Are you pending नहीं है? क्या है? आपका ये आइए डिसमिस्ड है. It has already been dismissed.
Sometimes we granted.
अपलोडेड ऑर्डर है. अब हम आपको क्या दिखाएं इसके अलावा? We will not do anything.
We'll file a certified copy itself. Sometime maybe 4 weeks time may be granted.
FA number 60 of 20.
But we'll file.
आपसे एक्सपेक्टेड नहीं था मैडम.
No,
नॉट एक्सपेक्टेड आउट ऑफ. ऐसे जूनियर के कहने पे खड़ा मत हो जाया करिए बिना रिकॉर्ड.
I tender apologies. But I just.
A petition which has already been rejected, you want an order.
I tender apologies. I did not. That's my mistake. I just did not. Went to the.
FA number 60 of 2019. Time till 15th of December is granted to the appellant to remove the surviving defects printed. If the defects are removed within time, posed this case on 18th of December.
I should have gone to the orders by myself.
क्या करता है आपका ऑफिस?
This is
Are you responsible for this file? You don't take out the print of the earlier orders, not required. The idea is to dismiss दिखाई है, but please, if I am not wrong, please have a look at it. देख लीजिए.
अभी making up this sloka, I was trying to go through
ये
the
2020 का order है.
I understand. There is no excuse to this.
You just have a look at it.
There is no excuse to this.
आपका तो ऑर्डर कर दिए हैं, नोटिस कर दीजिए. उसमें आपका
Correct.
रेस्पॉन्डेंट नंबर गलत है और जो आईए है आपका सारा लीगल प्रपोज लीगल हियर्स पर प्रीएम्प्टिव ऑर्डर अपीयरेंस नहीं रिकॉर्ड करना.
For orders item 10, second appeal 173 of 2008.
Please.
There are several petitions for shares, and the parties have settled that disputes. It's a suit for eviction. It was
Under BBC Act.
suit for eviction, Lord.
Settled.
Title eviction suit was filed by the plaintiff. He lost in both the courts below. Meanwhile, the original respondent died, who was my father. A substitution was filed that has been allowed by this honorable court, and the substitution was allowed in the execution case as well, and I have been substituted. Now we have come over a compromise with it. He said that he'll be paying me my rent, and I am allowed to get the disbursement of the rent that has been deposited in the court bill. And we have settled the matter. In case, in future, if the new dispute arises and he fails to pay the rent, we can again. This is the compromise.
So the matter is to be disposed of in terms of compromise. Why is there a petition for infringement?
Miller, there are intervention.
There is one interlocutory application, 9241 of 22.
9241 of 22. What is
This
it
is
for?
under order 22-4.
Hmm.
Now, what has happened that original plaintiff, he had a daughter, and she married outside the community. So therefore, the plaintiff had severed all ties. The final, kindly take annexure 1.
So what is your locus?
I am the town Khas Mahal lease was in name of the mother of the plaintiff and the interveners.
Name of parties.
So they were under, you were under BBC Act. The eviction was not under BBC Act.
He must pay.
The suit was under BBC Act.
Yes.
Your Lordship, may kindly take my IA.
No, just a moment. Two persons, landlord and tenant, are fighting. Whether you have the title or who has the title,
But the landlord had severed all ties with the daughter.
must have. But these two persons are fighting as landlord and tenant.
And now they have compromised.
They have compromised, and the compromise is only in connection with collection of rent. You were
I
not.
have not been served with copy.
Yes,
I
yes.
don't know.
Yes.
They have not-
What is the
They
compromise?
have no locus. Why
You have
will
no
you
locus. Let them compromise.
And it can be compromised.
I have
You- if
substantial
you have-
interest. I have substantial interest in the property.
Is
It is my ancestral
is he giving the possession by virtue of compromise? No.
I don't know what is there.
You just have a look at it. Where is it?
Miller, and right title and interest, nothing has been conferred in this. Only
Nothing.
the eviction suit. We have
Only
compromised.
the eviction suit. Nothing.
They can always file a separate suit for right title and interest. Just because I have a daughter and single only daughter, only legal heir of my father, now they are
And
harassing my
and if
uncles.
somebody has severed the relationship, does that a person is disentitled from inheriting the properties?
Under the Hindu Succession Act, if we convert,
What is the process?
this is a provision.
There must be a provision, but there has to be a process also to that. It is not so easy. Now the daughter is a co-partner. You disown her, you do whatever. Daughter is a co-partner under Hindu law. How do you disown? You see, it's not your self-acquired property that you will
Yes,
give
it
rights
is
on.
not my self-acquired property, neither the original plaintiff's self-acquired property. It was
That's
a joint family property.
That's right. Therefore, the daughter acquires the status of a co-partner.
Provisions of Hindu Succession Act.
You see, we can just say that only these two persons, being landlord and tenant, have settled their case outside the court, and therefore, because them, the appeal is disposed of in terms of the compromise.
Yes.
And this will have no bearing on the right, title, and interest possession, if any,
Yes.
of the interveners. Who are you?
Your Lordship, I have also filed an intervention.
For what?
Your Lordship, I am also one of the brother of.
Okay, therefore, right, title, interest, possession, if any, of any other party is not going to be affected. Simple.
Kept open. It will be kept open.
It will be kept open.
Understood.
And the tenant is still in possession, whatever be his possession. They had filed a suit for eviction. You are the landlord.
I'm tenant.
He's the tenant, I am the landlord.
I'm tenant.
There was a direction
And
for
she is now
eviction.
landlord.
There was a direction for eviction.
Yes.
Eviction. The suit was decreed.
At no point of time they appeared, my lord, that only my father filed the suit. They never appeared before any court.
On behalf of the your Lordship, leadership is aware, only there can be only one plaintiff. So therefore, that no occasion arose. It is only after death of the original plaintiff that we came before this honorable court saying that the original plaintiff had severed all ties with her.
That's
because
it.
she
So
married a-
whatever be your dispute with the original plaintiff, you will settle it in a different suit altogether. We will say that your right, title, interest, possession, if any, with respect to the
we had no conflict with the original plaintiff. It is the
That's
original
right.
plaintiff's
Daughter.
daughter who has been
substituted.
substituted, but he had severed all ties with her. And,
Very well. You will say that he had severed and therefore she does not have. But this is a absolutely summary proceedings of landlord tenant. Nothing to do with that. You will have your own title right, whatever you want adjudication, you will get
You
it.
can always file a suit for that if in case any difficulty is there. My lord, I am not allowed to enter my own house, my lord. After my father's death, I am nowhere. I am just suffering because of my uncles.
You file a partition suit.
I'll file.
Oh, you are the sole legal.
Yes, I am the sole legal head.
no,
I am
it is
the
in
one-
name of her grandmother.
Whatever it is.
That is not
I-
in the eviction suit.
Story is quite
I
complicated.
understand that, but
That is how eviction suit ke
I think that should be
Yes,
sufficient. I will keep your rights
Your-
open. Who are you?
Your Lordship, I am also one of the brothers of the.
Okay, claiming the property, claiming title over the property, both of you. Correct? देखिए आइए नंबर और क्या क्या आइए है इसमें
1032.
Just a moment. Adducing evidence, that should be closed. 2008.
Yes.
Then compromise is there, that is to be allowed. Then this is intervention 9241. Right. Then this is also this is a payment for arrears of rent, that will be closed.
That
Okay. Then there is an application for impediment 9662 of 23. That you are also claiming right. Okay. SA number 173 of 2008 with IA number 10132 of 25, IA number 2717 of 2008, IA number 9241 of 2022, IA number 9670 of 2023, IA number 9662 of 2023. The counsel for the appellant and the respondent submit that the matter arises out of dispute between landlord and tenant, and they have settled the dispute outside the court, and accordingly a joint compromise petition has been filed, being IE number 10132 of 25.
10132.
10132 of 2025. They submit that the appeal be disposed of in terms of the compromise. The appellant hearing was the tenant with respect to the suit property. They submit that if the compromise petition is allowed, then IA number 2717 of 2008 for adducing evidence need not be allowed. They have also submitted that another IA, being IA number 9670 of 23, seeking direction for payment of arrears of rent, also need not be allowed.
That may be allowed, because we have compromised.
It is in terms of
Yes,
compromise.
it is there.
You have deposited below there.
That's right.
Yes.
And the arrears of rent, if any, has been taken care of in the joint.
Yes.
She will be able to.
That's it. So far as the IA number 9241 of 22 and IA number 9662 of 23 is concerned, the council submit that these are interlocutory applications where the interveners seeking intervention in the proceedings, as the interveners are claiming title, right title, interest, etc. over the suit property. The counsel for the respondent landlord has submitted that the matter in the present case essentially arises out of landlord-tenant relationship. If the person seeking intervener have any grievance, they have a remedy as per law. She submits that those interlocutory applications may not be allowed. The learned counsel appearing on behalf of the interveners in these two interlocutory applications has submitted that the respondent landlord in the present case, the respondent in the present case is the daughter of the landlord and has been substituted. They have submitted that since the daughter was excluded लिखे क्या लिखे?
Yes, the original plaintiff severed all ties.
Since the original plaintiff severed all ties with the present defendant, present respondent, therefore the present respondent does not have any right title interest with respect to the suit premises, and these two interveners claim to have right title interest etc. with respect to the suit premises. However, they submit that if this court is not inclined to allow the interlocutory application seeking intervention, it may be observed that the interveners may have their right, and the right of the interveners be kept open. Right?
Maybe
After-
one observation, if possible. Because the lower court and where the amount is, the areas of rent is being built, we were not being allowed to take those areas.
Yes, yes.
So that may be indicated in the.
Your substitution was allowed, no?
Substitution was
We will
allowed.
not indicate anything. Once a substitution is allowed, the court is bound to take care of it. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the dispute between the plaintiff and the original defendant arose out of landlord-tenant relationship, and the suit was decreed. The tenant lost in both the courts,
Yes.
and ultimately the second appeal has been filed. And now it is also not in dispute that the respondent hearing was substituted at the stage of trial.
In the executive, those are by requirements during the pendency of this appeal.
Okay.
So are
Was-
they substituted in the executing?
was substituted in the executing court and also before this court.
This
Yes.
And also before this court. Considering the nature of dispute involved in the present case, this court is not inclined to allow the intervention application wherein the interveners are seeking right title, interest, etc. with respect to the sued property, as their intervention is beyond the scope of the suit itself. However, it is observed that the interveners, it will be open to the interveners, their right. However, their right, if any, with respect to the suit property, will remain unaffected by this order. So far as RA number 103-10132 of 25 is concerned, since the appellant and the respondent have settled their dispute outside the court, and have filed joint compromise petition, the second appeal is disposed of in terms of compromise, whose conditions have been mentioned in paragraph 5 of the interlocutory application. Pura quote kar dena hai. Since this second appeal is disposed of in terms of compromise. IA number 2717 of 2008 for adducing evidence is closed. Okay, sir.
Deeply has to be prepared also in terms of the compromise.
Office will prepare it.
Oh, yes, obviously.
सारा ये और तो कोई बचा नहीं, 4 आइए तो 5
एक कॉम्प्रोमाइज
2 इंटरवेंशन और 1